I appreciate all of you coming out. Obviously, you've had plenty of coffee during the day, so you're still buzzing. So it's exciting to see everybody here. And for those of you getting all of your education units, congratulations on doing that. We have two of our major sponsors here this evening. We have Leslie Lyons with Manufacturers Bank. They're sponsoring the Night Owl session here. So I'd like to welcome on stage Leslie Lyons. Leslie.
Thank you, Richard. Good evening, everyone. Manufacturers Bank is excited to once again be sponsoring the Night Owl session. And my name, as you know, is Leslie Lyons, and I am one member of a 3-member team of fiduciary bankers representing Manufacturers Bank. And my other team members are here with me tonight, and I'd like to introduce them. Sui Chen and Scott Kunitz. We have had the opportunity to meet many of you at the various PFAC organizations, fiduciary roundtables, estate planning councils, and bar association meetings. And we have learned over the 6 years that we've been participating in the fiduciary market, we learn from each and every one of you every single day. So we love being at a conference like this because we just kind of glean as much information from all of you as possible. We do recognize that as a fiduciary, you wear very many hats, and the last hat you want to wear is something to do called a banker. You don't want to be your own banker. So what we do as a fiduciary team is we hope to simplify your banking by letting us do it for you. And we help you simplify by streamlining your account opening procedures, providing you with a complete online set of tools to manage all of your cash management, and especially consolidation of your banking with expanded FDIC insurance. For those of you from Southern California, you have heard us all speak endlessly about our ICS product, or Insured Cash Sweep. And we love this product, and we think that fiduciaries do too, because it's a money market account that's liquid, interest-bearing, and allows you to maintain accounts, one client, one bank, one account number, up to, if you have a client, up to $110 million without having to spread it amongst many other banks. So we would love to tell you more about the ICS product. We will be here after the session tonight. We have a booth in the exhibit hall tomorrow. And so we're available to answer any questions you may have. And also, finally, we have a raffle that will be out at the end of the session. So don't leave before it's over. If you haven't put your business card in our fishbowl, it's out in the front by the wine. And we'll look forward to seeing you at the end of the session. Thank you.
Thank you, Leslie. It is absolutely critical for the fiduciaries, the established fiduciaries, the newer fiduciaries to get to know each of our partners as you go through this conference. So please make time to see Leslie and her team and build up that relationship. Even if you don't need them right now, get the cards and get the introduction to the business. Our gold sponsor for the conference here is Merrill Lynch, and Merrill Lynch has been an absolutely amazing partner for PFAC as an organization and the individual fiduciaries doing a lot of the investment management. So we have, representing Merrill Lynch, we have Dan Cutter with us, so I'd like to invite Dan Cutter up to say a few words. Dan.
Thank you, Richard. My team totally bailed on me, so I'm the only one here. Wanted just to say thank you to Richard and David Keeler for putting on such an amazing event. It's always great coming to these events with fiduciaries, and it's almost like a homecoming, right? Or a family reunion. Every year you see new people, you make friends that you hadn't seen in a year, and you make that friendship, and it's immediate. So it's great to be here, and we want to thank you very much for all the business that you've given us and for all of the work that you do, because the job is not always a thankful job, right? You got a lot of bad actors out there and a lot of folks who are not really interested in what you have to say, and you're doing a great job of taking care of them. And it's an amazing thing to see and be part of an organization that just raises the integrity of everything. So we wanted to thank you for that. And you know, that $100 million account is a great business product, but if you want to invest a little of it, maybe just just the interest. We'll maybe take some of that interest and try to do something for you. The other quick little thing I want to share was a story which I thought was funny. About a year ago, I went home, and I've got 4 kids, and one of my daughters had a bunch of friends over, and she's talking to her friends, and they're all saying, "Hey, what does your dad do?" and blah, blah, blah. And she goes, "My dad works with fiduciaries." And they're like, there's a big pause in the room. And they're like, "What's a fiduciary?" She goes, "I don't know. I just love saying that word." So for all those little 11-year-old, 12-year-old girls, thank you for taking care of their trusts, taking them to school and doing all of those things. So we really appreciate all you guys do. Thanks a lot, and have a great conference.
Thank you, Dan. We actually promised Russ that we would extend the introductions here and the sponsors for most of his presentations. So we have another 15 people to call up here. But seriously, I'd like to introduce Russ Marshall, our speaker for this evening. Russ owns Marshall Fiduciary Services and provides full fiduciary services to his clients in Campbell, California. He is a national master guardian. And this is really quite a big deal because in the United States, there are only 55 national master guardians. And to give you an idea of that scale, there are over 700 licensed California fiduciaries, so he's really in that very elite group. Russ has been extremely active over the years in fiduciary legislation. Russ was very active in our licensing bill, SB 1550, that led to our licensing in 2008, did a lot of the background drafting of the legislation. Russ was also, and some of our legislation through PFAC is what doesn't happen. And one of the things that happened a couple of years ago was that there was legislation being propounded to limit and severely contain our fiduciary fees. And Russ was part of a group of us that went to Sacramento, met in Governor Brown's office to veto legislation. So this is some of the background work. Russ is just an expert in doing all of those types of things. Some of the current legislation, I apologize for repeating things you may hear later on, some of the current legislation that we're looking at is to be able to form personal corporations for fiduciary practices. So again, Russ is leading that charge for us, so thank you. So please welcome Russ Marshall. We're going to have a walk through the national ethics. So Russ, welcome.
Thank you, Richard. And of course, Richard was a part of all of that too, with the legislation for the licensing, the vetoing. He and I both met in Governor Brown's office to get that bill vetoed, and he's been a part of the efforts to get professional corporations, professional fiduciaries to be organized as a professional corporation. Well, today what we're going to talk about is the National Guardianship Standards of Practice and how my own personal opinion is about how those standards relate to ethical behavior. So when I first put this program together and did it for the NGA probably 6 or 7 years ago, NGA had standards of practice, but they didn't really have a code of ethics. They had like a code essay, which was several pages long. And I wanted to present something to NGA members that showed them how the standards of practice could be related to a code of ethics for them. And so I put that program together, and NGA asked me to repeat it again last year at their conference in Charleston, South Carolina, which I did. And I presented all the PowerPoint and so forth to get the program approved. And between the time I presented the PowerPoint to them and the program, the conference actually took place, NGA passed this ethical standards principles that they have. So then NGA now has ethical principles, which I didn't include in the PowerPoint for the NGA, but you get to see it here. So they didn't tell me they were working on ethical principles, but here it is. So these are my version of the NGA standards that are related to the ethical principles. So, oh, I guess I need this thing, huh? Doesn't automatically work. Okay, these are the ethical principles, the NGA ethical principles. First, the guardian treats the person with dignity. And this is one of the most important things. This is actually the reason that we're in this business is to treat our clients with dignity. We do this because it's the right thing to do, and everybody has a right to be treated with that kind of dignity. It's actually in some of these things are actually in our probate code in California. The other ethical principle, second one, is the guardian involves the person to the greatest extent possible in decision making. And the big thing going around in national guardianship circles right now is a thing called person-centered planning. And when I first heard about person-centered planning, it's about empowering the person to make their own decisions about their own care, their own management of their estate, helping them make the decisions they need to make for managing themselves. And it was about kind of like a group of assistants, care providers, care managers, CPAs, family members, getting together to form a group to help a person with the decisions they need to make to manage their care and their estate. And when I first heard about that, I thought, it sounds like institutionalized undue influence. But but it really isn't. Because the people who do this, the people who are involved in these decision-making things, the efforts and sessions with the person under protection, are doing so because it's the right thing to do. So let's go on from there. And actually, you can take a look at this, this ethical principle and relate it to the standard of practice that NGA publishes. The standard number 9 is all about this, how to implement this particular ethical principle. By the way, that should all be, not only this PowerPoint, but the ethical standards or ethical principles and the standards of practice should all be in your flash drive. And I don't know if you've seen that or not, but even if you haven't, you can download those from the NGA website for free. The third ethical principle is selecting the option that places least restrictive persons' freedom and rights. And of course, that's in our code. Least restrictive alternatives are all over the probate code about how you treat a person under conservatorship. So this is something that we're quite used to. Going on for the ethical principles, the identify, advocate, and advocate for the person's goals, need, and preferences. And of course, this is something that you'll see in the NGA standards in number 7 when we get to that. But this is so basic for intaking a new guardianship and conservatorship case, is what does the person want? And primarily, it's what is the person's preferences, and you need to know this, about medical treatment options, about burial options. Those are things that are difficult to talk to a new client about, but it might be easier to talk to the family, the friends, the neighbors, the church members. So it's something that you need to gather information about when you first take in a new case, but it's so important to get information about that. Maximizes self-reliance and independence. This is something that I really like to do, and I'll talk to more in depth about this later, but it's about least restrictive. It's also about making sure that the person can do as much as they possibly can do. I like to give my clients homework. You have to go home and think about this, or I'm going to give you this information. I want you to think about it, and next time I come back, we're going to talk about it. And sometimes they think, oh, I can't make that decision. I don't know what you're talking about. Think about it. I'll come back and we'll talk about it again. They feel so empowered that I'm giving them the option to even discuss something about the management of their estate or the management of their care when I'm the person who's responsible for all of that. And it empowers them to think about all of that. Because maybe they can't make that decision. Maybe the court says I have exclusive power to make those decisions. But I've given them the option of giving me the feedback. So there's another one about confidentiality. We've had so many talks in so many conferences about keeping the affairs of our persons under guardianship and conservatorship confidential, but it's right there in the NGA standards of practice number 11. Avoiding conflict of interest, it's another thing we've talked about, and we'll talk about it more in depth a little later, about avoiding the conflict of interest and even the appearance of a conflict of interest. And I'll talk to you about a standard that I use when faced with an issue about is there a conflict there or not. The next principle is about complying with all the laws, and I think that kind of goes without saying, but there's some questions somewhere that you might encounter in managing a case about complying with a law. That we'll talk about that when we get into talking about standard number 2. Managing financial affairs carefully. I like to say that I'm managing your financial cares to my clients. I'm managing your financial affairs better than I would manage my own. And of course, if they really saw my own, they'd know everything is going to be managed better than my own. But better be. Anyway, so, and the other thing, then the next standard is about respecting the money and property managed, that money and property belongs to the person. I don't think we have any problem understanding that ethical principle. We'll talk about that standard in number 17. So here are the standards now. We finished with the ethical principles, now we're going to talk about the standards. And you know what, this whole talk is something that we always get a lot of feedback from the audience and a lot of questions and a lot of information from you, and I kind of expect that. But I should have done this in the beginning. Those of you that are sitting way over in the wings, I can barely see you, let alone the people in the middle hearing what you have to say. If you could move a little closer while we start this, while we're talking about these standards, that would be really helpful. So, number one, this standard number one is about following the applicable law. This is about states that have code of ethics, about they're applicable to guardians in their own statutes, but these regulations that they have in the states are sometimes not followed by the guardians because in those states because they're just out there doing what they need to do to manage the client's estate and affairs, but maybe they're doing so without the representation by an attorney. And in other states, you don't have to be represented by an attorney necessarily to be a guardian or conservator. In California, I think there's a professional code in the standards of professional practice for attorneys that says you can't, as a fiduciary, if I go into court and I'm representing another person as a fiduciary, that I'm practicing law by representing another person in front of the judge. So I can't do that without a license, so I have to have an attorney represent me. So this standard in terms of following state law and be guided by professional codes of ethics and being represented by counsel, which is basically what this says, is actually codified even stronger in California than it is nationwide. And the other thing about this standard is the NGA standard here is that it applies to professional guardians and professional conservators and professional fiduciaries even at a higher standard, holds them to a higher standard than you would a layperson. And I think we're seeing that, and we're looking at that in the courts. The courts are actually holding us to a bit of the higher standard than they would a layperson. Standard 2 is the guardian is not act beyond the powers granted by the court. Well, what's that mean? I mean, if the court granted you powers, and what kinds of things would you be even tempted to do that are not granted by the courts? Anybody have some idea about things that you might do? Why? First of all, why is it related to ethical behavior at all? You have something that you need to do, and it's not something that the court granted you the specific power, and it's not worded as a power in your appointment documents, but you want to do it. Should you do it? Should you get instructions from the court? Okay. So suppose the hospital calls and your client's in the hospital and they want you to come down and sign a no code. But you don't have the power, you don't have the exclusive power to consent to medical treatment. Should you sign that no code just because they got to do it right now? And what's your client going to go through until you get into court and get the exclusive power to consent to the medical treatment and get the authorization to sign the no code? Should you do that? What's your client going to go through in the meanwhile while you're getting all that court authorization? See, that's what this standard is about. Making sure you understand what you're authorized to do by the court. Making sure that what you're authorized to do is what you do and nothing more. That's what this standard is about. And making sure you understand that if there's some kind of a question about what you really are authorized to do, that you ask the court for instructions. So if the court order is ambiguous, you got to also recognize that court orders are drafted not by the judge, but they're drafted by the attorneys. It's very rare that that a judge actually drafts his own court order. The attorneys are drafting the court order. So if you're the petitioner in the case, your attorney should take instructions from you about what you want in that court order. So don't just sign the petition, because many times the prayer in the petition is simply cut and pasted into the order. And whatever you sign in that petition is what you're going to get in that order. Make sure you understand what you're signing in the petition and what that's going to mean as the output from the court when you get that court order. And if you don't understand, say, I don't understand. So, okay. Here we have the standard about treating with dignity and avoiding personal conflicts, personal relationships with the person under protection from the guardianship. There are several people that I know in my own chapter that are very friendly with their clients and very friendly with their conservatees, and they take them to birthday parties and they transport them to visits with their family, and they feel that that's an important relationship. And I kind of take a step back from that a little bit, and I'm thinking that person who in some cases may be estranged from their family is then dependent on me as the guardian or conservator. And that dependency becomes more of a personal relationship than a professional relationship. And I have a problem with that because I can be replaced as a conservator. And then they have another loss. They're separated from their family. They've lost their family. They've lost their loved ones. They're estranged from one another. Otherwise, they wouldn't have had me in the case in the first place. And then I'm replaced by somebody else. And they have another loss if they see me in that personal relationship. So I want to make sure that whatever relationship I have with them, it's always seen by them, and me, of course, as a professional relationship. And I think that's the ethical standard that I want my practice to adhere to, and I think that's what this particular standard is talking about, is making sure that your relationships are professional, not personal. It also can lead to more demanding requests that you might not be able to comply with. If your client needs to go somewhere or wants to do something and you've got another appointment and it's more important and you have to turn them down, and then you have a different appointment, emergency appointment gets in the way and you can turn them down again. And I had a client just call my office just the other day, and he complained to my staff because he'd called me 3 different times and I'm not there or on the other line or whatever it was, and he wouldn't leave a message. He would just say he's never there. He never answers my call. Well, it's not true. I would have answered his call if I was available to answer his call. So I went and visited him when I talked to him about it. And when I talked to him about it, we were with his doctor. And his doctor said, called him by name, said, "That's not appropriate behavior." And the doctor got involved in appropriate behavior with him about how he should behave with people that he has a relationship with. And I thought this is the doctor I want to take more of my clients to. Okay, next one. Well, I don't know that we really have to talk about that one. But it is one of the NGA standards. So it's there because of that. Okay, so let's talk about this one because it really is talking about person-centered planning, and I referred to that a little earlier when we were talking about the ethical principles. Has anybody taken any courses in person-centered planning? Anybody have participated in a person-centered planning session? I think it was more developed to relate to persons with developmental disabilities because it really focuses on growing that person and allowing that person with a developmental disability to realize their potential. But I think that working with our elderly, disabled, mentally ill clients, that might be a good thing to try also. A little bit different twist to it than person-centered planning, as I described it earlier. But it really is about looking at what the person can do, what they think they're limited in doing, and trying to get them to achieve something more than they can. And I know that you're talking about your dementia clients, and that disease is devastating and progressive, and it's going to continue to get worse. But at each step of the way, each day, each hour, you can challenge them to do more than they've been doing. And I think that that challenge in that demented brain can continue to make that person feel more dignified about what they're going through. Because after all, the biggest thing they have going right now for them is fear, the fear of the loss. And I think the more power you give them, the better off your conservatorship is going to be. So the other thing in this slide is about surrogate decision making. And that really is about somebody who gets involved in making decisions for a person that's mentally incapacitated in one way or another. And we all know what that means. But it's also about finding out what they would have wanted. And you know, when you get involved in a case and you're first appointed in a case, one of the things you have to do is find out a bunch of information about the client and what they would have wanted, because you're going to be stepping in their shoes. Almost literally. You're going to be making decisions for them, daily decisions about managing their care, about managing their money in a way that they would have made when they were capable of making those decisions. So it's an extensive interview process that you go through to determine what decisions to make and how to make those decisions in each and every case. The other thing about this is your relationship with the person is understanding your responsibilities as guardians and conservators, what is the legal process of forming a conservatorship and a guardian, and making sure that you're state certified. And of course, I just came just before this session, I came from a meeting with new first-time attendees at the conference, new members of PFAC, and they're concerned about the state certification process, the state licensing process, the membership in PFAC, the potential membership in NGA, and what all does that mean? And what that means to me, and I said it to them, what that means to me is that if you only take the licensing exam, that's really all you need to do to be a professional fiduciary. That's the bare bones. That's the ground floor. If you want to rise above the ground floor, you could become a member of PFAC. If you want to join an organization that promotes high standard conservatorship and guardianship nationwide, you can join NGA. If you want to be the cream of the crop of NGA, you can become a National Master Guardian. And so that's the goal that I would aspire to in my conservatorship practice. And there's a lot of people in this room that could achieve this NGA standard. They just have to take that test and get it going. So the next one is about personal relationships. This is so important because the preferences that your client has about who to have a personal relationship with. I have a client right now that has very difficult personal relationships. He's got a lot of people living in his house with him that he's developed relationships with for years and years and years, and they're not relatives. They're, you know, a twin. One of the twins lives in the living room. The other twin lives in a bedroom. The guy who came to live with him when he's 14 years old because his parents kicked out of the house is living in another bedroom, and these people have been there for 30 years. And I'm involved as the conservator for this person. And it's very difficult to provide in-home care when you have all these other people in the home that have their own needs. But it's very disruptive to him and his person and his lifestyle if we just get rid of them so we can put care in the home. So we have to have an agency that's willing to work with these people, willing to work with all of them in the house and keep them, you know, adhering to certain standards, because we have to have some standards for, you know, cleanliness and privacy and all the rest of that. But so we set some standards up. We have an agency that's working really well with them, and we've got this working fairly successfully right now. But you have to understand what his needs were, what his lifestyle was before he went under conservatorship and guardianship, and try to honor that. And I had discussions with several of his friends who are from out of state and very successful business people, and an attorney from New Mexico and who understands all of this, and his brother who's right here in San Jose who knows all. These people, These people know this person, know him when he was successful and the way he wanted to live his lifestyle, and this is the way he wanted it. And we're going to honor that, and we're going to try our very best to make sure he continues with that. So we encourage him to maintain these relationships. Understand also that if you're encouraging somebody to maintain relationships, and you get involved in a case because the family's warring with one another about who should be in charge of dad's money, when dad can't manage his own money, and you're the person who takes charge, that this war that's been going on for many years, dad may not want to be part of it anymore. He may be relieved that he doesn't have to be the center of attention for the warring family members. So you have to actually understand what the client wants and deal with that. Sometimes it's good to get the people who are warring with one another to stop the war. And I remember there was a case that I had when I was very early in this profession, that I had the two 50-something-year-old brothers come into my office who were fighting about dad, and I was appointed as dad's, well, I was the trustee for dad, and because they were fighting about managing dad's multi-million-dollar estate. I said, you guys need to not fight about the money anymore, because the money is under my control now. The money's off the table, so you can just go be sons and brothers again. And how did all this start in the first place? And the one of them turned to the other and said, well, I think it's all started when you were 16, you got a pair of skis and I didn't. And they've been carrying that baggage for all those years. And I took my rose-colored glasses off and I said, I'm not going to be a counselor. That's not my job. I'm not going to heal these family relationships. I can put it out there. If they want it, they can come forward. But I'm not going to be the person who's going to heal the family relationships. And in fact, dad was pretty demented, and he could care less about the war of the family. He was happy that somebody was keeping his money safe, and that was me. So when you chose a side, the only side you choose is that of your client. So now, again, this is part of what I was talking about a little earlier. Assist the person who you're protecting, either it's a guardianship or a trust beneficiary, the settlor of the trust, in maintaining the relationships, and even if they're absent from the home. And what this standard means is that if you have to place somebody in a hospital or a skilled nursing facility, even temporarily, make sure that the people who are involved in the case know that you've made that placement. And you make sure that your client also knows that you're telling those people that you made that placement. It may be the client said, no, don't tell them. I don't want them to know. And that's okay. Then you probably don't tell them. You don't have to. But the other part of it is, suppose then the people come back to you, the family comes back to you and says, you didn't tell me my dad was in a nursing home, and you didn't know it, but a couple of days later he might have had a stroke and passed away. And they didn't even know about that, but you didn't tell them because dad didn't say that. So that's a difficult situation that you find yourself in. So I don't know what that best way to handle that. I think that if I had dad in a nursing home, I'd probably get somebody from the nursing home staff to come in and say, dad doesn't want me to tell his family that he's in the nursing home. Can you come in here and verify with me that he's telling me not to do that? And so I've got a second person to verify that I was instructed not to tell anything about dad being in a nursing home. The other thing about that, yes, go ahead, question. I was just thinking about the ombudsman. The ombudsman is not immediately available, but they're pretty quick to respond. So if the ombudsman is somebody that you could call about that, then you get the ombudsman there too to verify that this is what your client is telling you. And of course, discuss it with your counsel. Because your counsel may say, you know what, this is the type of case, because not only the family members are involved, but the attorneys that they've all lawyered up with. This is the type of case that you may want to just go to court and get instructions from the court. And then, of course, you've disclosed that dad's in a nursing home because you've gone to court. So the other thing to do with standard 4 here in maintaining a relationship with family members is making sure that you're notifying the family members when you dispose of assets. And there's certain there's standards or probate code sections that require you to give notice to family members about when you're disposing of assets. Also, Make sure that if you're disposing of assets as a trustee and your trust settlor is still alive, that you're notifying the people who are in that trust if the assets are to be specifically bequeathed to somebody, that you notify them that you're going to have to liquidate that asset. Because you don't want to be liquidating an asset and then when your client dies, the person who expected to get it finds out you sold it. So make sure that you have a question over here.
In the case where you have to liquidate an asset that has bequeathed, that would have been bequeathed,
Mm-hmm.
do they have any recourse?
Do they have recourse?
Does the beneficiary have any recourse?
They do. They can sue you. If you sell an asset, that is specifically bequeathed to somebody who's in a trust document, or even if you're in a conservatorship and there's a will, and you know of the will, and that will specifically bequeaths that asset to a person, if you've sold that, does that person who was expecting to receive that?
Assuming, of course, that you needed to do so for financial.
Well, and of course you need to do so for financial reasons. Can that person then sue you? Yes, of course they can. But do you win or not? It depends on the circumstances. And will they sue you? Maybe. But if you tell them ahead of time, look, I got to sell this because Dad needs the money. You know, I now have a Walgreens store in Oregon that's in escrow, a $5 million sale. Dad is going to live maybe 18 months. He's not going to need $5 million in 18 months, but he's going to need something, so we have to sell the Walgreens. And so I notified everybody in that case, and they all know that we need to sell that, and everybody consented to that sale because they all knew that Dad needed the money, even though he doesn't need the whole $5 million. He needs some of it. You have a question, Molly? Yes. I think I just repeated that question, but not in the form of a question, but as part of my answer. So, but thank you for the reminder. Other question? Yes.
Just going along with beneficiaries in a trust or in a will, I'd also mention be very careful when marshaling accounts or consolidating accounts. Be mindful of pay-on-death beneficiaries that are named for those accounts.
Now, Will brings up an interesting point. And it depends on your authority, Will, but what Will is saying is be careful when you're marshaling an account to recognize that the account you're taking into your control and maybe even closing the account might have a pay-on-death or transfer-on-death beneficiary listed on that account. What do you do with those, Will? Let's say you're the trustee and that trust asset is not titled in the trust, but you get a Hegstead order that says that account it should have been titled in the trust. What would you do with that?
I haven't dealt with it in a trust. I dealt with it in a conservatorship.
Conservatorship. Okay, what did you do with it in a conservatorship?
I made sure that we kept the things intact that were pre-planned
Okay.
and worked with the bank on that.
Okay, he made sure that they kept the accounts intact that were pre-planned. So what you would have had to do was to leave that account outside of the conservatorship. Couldn't be titled in your name because if you're titling it in your name, you have to close it, right? So you have to leave that account outside of the conservatorship and leave the pay-on-death beneficiary designation in place. But how do you freeze that account so somebody else can't come in and get that? How do you freeze that account so your client can't, with his caregiver, drive down to the bank and take the money out, which has happened to me. So Will's got a good point there. Leave that money there, but make sure that account is frozen by the financial institutions because you're leaving it there, and you, of course, report to the court that here's this account. It's conservatorship funds, but you're leaving it in the existing account because of pay-on-death designation. Does anybody have an alternate course of action for that?
How does that happen? Doesn't the bank tell them that's a payable on death account? I mean, how does somebody else claim to it?
Well, they can't make a claim to it until there's a death because you have to go in there with a death certificate. But suppose your client with his caregiver went down to the bank, drove to the bank, and decided to withdraw some money from that account because he knows he's got the account. He remembers he has the account. And by God, he knows that's the only account I got left because Marshall took all my other money. And I still have that account come on, drive me down there. I'm going to get my money out of that account. So he goes down, he takes that money out of the account. If you tell the bank that you're the conservator and you want the account frozen, then even your client can't get the money out of the account. Unless, of course, the caregiver figures out, this has happened too. The caregiver figures out how to go online and change the online access to the account and then pulls the money out and puts it in the caregiver's account. Yes. That's happened. Yes. 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 Of course, the bank is at fault for that, and the bank pays the money back. Yeah. And you file a police report. And call APS, too. Not just a police report. You have to call APS, too. Even if the police officer says, don't worry, I'm going to report it to APS. You're the first party. The police is the second party. First party calls APS. So don't rely on the police to do it, even though they do, because you'll get called by the court investigator. Why didn't you report this to APS? Yes?
Is it possible to close that account but keep the same death benefit so the caregiver can go online or do whatever?
I don't think that as a can you close the pay on death account and keep the pay on death designation intact somehow while putting the money in a conservatorship? I've never tried that, so I really don't know. Anybody work for a bank that knows whether you can do that? Can't do it? Can't do it. Where's Ben? Ben here? He used to work for Wells Fargo. If Wells Fargo lets you do it, anybody will. Yes. Pardon me? I'm sorry, couldn't hear you. Oh, she says, here's a good point. If the pay on death funds are the only funds you have available to you to manage the conservatorship, of course you have to take that account in, but you have to notify the pay on death beneficiary that you're doing it. And there's no other choice. No other choice but doing that, yes. But you take the account first, yes. Well, no, but Robert, you take the account first, but I think you're anticipating maybe that the pay on death beneficiary will go down with a falsified death certificate to try to get the money. That's another police report. Any other questions? Yes. It's hard to see with these lights. Yes. Okay. So you have a substitute judgment trust, and there's one item of personal property that the conservator, settlor of the trust, through your substitute judgment action, wants to go to a specific person. No?
No, the conservatee herself doesn't care or know about it, but the son wants that one item.
Oh, the son wants the one item. The son wants the one item, but the trust doesn't give it to the son. Okay. The son got notice of the 2580 petition, the substitute judgment petition, to establish a trust in the first place. Son had his day in court, opportunity for a day in court, could have come in and say, I wanted that item, put that in the trust disposition, and he didn't do it. You can say, gee, you know what, you didn't do it. I'm sorry, I can't help you with that. But yes, you jumped ahead of me, but that's exactly what I was going to say. When you go to actually liquidate that estate, you can tell the son, we're going to liquidate the estate, including the item you want. Go to the estate sale, go to the auction, however you're doing it. Here's a notice of when that's going to happen. You can bid on the item. That's the best I can do for you. Unless Sonny Boy wants to go into court and get the trust that you established through 2580 modified. I mean, maybe you could do that, but for a $25 item, he's not going to do it. Notify him of the estate sale, and he'll go down and buy it. That's not really ethical stuff, but anyway, we got into that, so we'll go ahead and do it. Okay. Okay, keeping family members notified. How do you keep the family members notified when there's end-of-life decisions that need to be made? What do people do about that when the client's going on hospice? What kinds of notifications do you make to the family member that, you know, the nursing home is called, we're going to have to put mom on hospice? How do you go about notifying them? Telephone call? Sure. Okay. Do you notify each and every one of them? Yeah. Do you treat them differently because one person is so involved and the other one doesn't care? No. No, you notify each and every one of them because it's their parent, their loved one, their family member. So you have to keep them involved. Good communication goes a long way. And to underscore that, when I was the chair of the ethics committee, so many of our complaints, the vast majority of our complaints about ethical behavior, was about failure to notify me about something that's going on, or failure to even return a phone call. That created a complaint. And so communication is huge. Just that's, you know, as my experience as chair of the ethical committee many, many years ago. Your question, yes.
What would you do if your conservative tells you that he has a medical condition and your conservative tells you that, no, do not mention this to any of my family members of this medical condition? What can you do?
If the conservatee tells you, no, I don't want any of my family members to know about my condition, do you honor the conservatee's wishes in not notifying the family members? How many people say, yes, you honor those wishes? How many people say, no, you have to notify the family members regardless? So that's the consensus of the group. It's a really tough decision because you know to protect yourself, you will need to notify the family members, right? That's going to protect you. But is it what your client wanted? No. So what I would do, though, is not necessarily to, obviously you've got to talk about that with your attorney, but the other person I would tell is the court investigator, because maybe the court investigator is the one person who's going to hear from the family members about, he didn't tell me about this stuff. And if you've jumped ahead of the family who might complain later about that and told the court investigator doesn't have an obligation to tell the family members, but the court investigator then comes on your side in that case in defending the client's wishes. So a lot of this stuff is about how you bring people in to be allies in your case. And that's a way to bring the court investigator in to help you. Okay.
Client has dementia, and the dementia is aimed at the family, and the client says, don't tell my family.
Well, you know, there's different levels of dementia. Is the client if the client has dementia and the dementia involves the family members, the paranoia that comes from dementia is involving the family members, and the client says, don't tell my family members, but you know that that's a demented response, I think you have to kind of judge for yourself about whether the client had capacity to make that request of you. And if you think that the client really doesn't understand the impact of that, you could talk to the client about more in depth about making decisions like that and excluding the family members from something that might be an end-of-life decision. You also might want to get involved if the client's in a nursing home or a hospital, might get the social workers in the hospital involved to help you discussing that with the client, because they're skilled at dealing with that. They see it every single day. Anybody else have any ideas about that?
You could get the ombudsman in that one as well.
You could get the ombudsman in that, but depending on the placement, you get the ombudsman in helping you with that decision about whether you should notify family members, even if your client is too demented to tell you whether they should or not. Molly, you had your hand up?
The conservatee, they have their own council, a court-appointed council, that for some reason is still involved with the case. So you may want to chat with the conservatees at the council.
Well, Molly's suggesting that you chat about this issue with the conservatees court-appointed counsel who may still be involved in the case for some reason. Involving court-appointed counsel is something I can go into later, because I think sometimes you can even make them your ally in a case. But recognize that if you're talking to court-appointed counsel for the conservatee, that's potentially opposing counsel, and maybe actually opposing counsel in your case. So be careful when talking to that person. And if you're at all uncomfortable in talking to a person who's an attorney who does not represent you, say, stop, wait a minute, you need to talk to my attorney. Not going any further. Not going to talk to you any further. Talk to my attorney. So that's a case, Molly, where I would I would judge for myself whether I thought that I could relay that message and it would be received professionally, or whether I relay that message and it would be received and cause a conflict. And if it caused a conflict, I would have that presented through my attorney to the conservatee's attorney. Another question over here.
Wouldn't that attorney have an obligation to his client?
Pardon me?
Wouldn't that attorney have an obligation to his client?
You know, I don't know because I'm not an attorney. And this isn't a course about what an attorney has an obligation to his client about. And many times I've seen, especially with court-appointed counsel, I've seen court-appointed counsel wanting to simply do the right thing and not necessarily following their client's instructions to the letter. So it depends on the counsel, it depends on the client, and as I said, this is not a course about attorney-client relationship. So we can't go much farther than that.
One other thought.
Yes, another thought.
It's going to be the family member that gets contacted after the death to deal with the disposition of the conservative body.
Yes?
So they're going to find out about it in a matter of days anyway. Right. So, I mean, you're not going to get off to a very good start if you let the person die without telling them.
Okay, so you're talking, what she's talking about is that if your client is going to die and you don't tell the family members because somebody told you not to tell the family member, and all of a sudden the family gets called by somebody other than you to say your loved one died, then they're going to look at you and say, why didn't you tell me? Well, you've done all you can, because we've got several ideas here about protecting yourself because you followed your client's wishes. So I know that it's going to get you in some hot water with the family member who wanted to know that their loved one was dying, but you've got the ombudsman involved, you've got their court-appointed counsel involved, you've talked to the court investigator, and you talk to your own counsel about your decision, about the reason you made that decision. Maybe the court investigator might even want to visit the conservatee if they've got any time, if they're out in that facility anyway. So you might have a bunch of different people that are on your side in this, and that's all that I'm telling you about, is get as many people as you can to back you up. Don't simply make that decision in a void, okay? Next is treating professionals and service providers with courtesy and respect. Sometimes you might get confrontational with your service providers, and you might be in a position of instructing them what to do and making sure that they're following your instructions. But yeah, I just think that it's so important to view them as a team. I remember one case that I had where we had a client who, for some reason, he married a woman that's about, probably 35 years younger than him. And so he didn't want any other males in the home. We had to have care. We had to have care in the home with females. He would allow me in periodically, and I don't know why I was the only guy who got in there. But he wouldn't have any males in the home. So his water heater's leaking, right? So I had to have a plumber come over. So I called all over the place to find a female plumber that can change the water heater. There weren't any. So I called the plumber that I use most often and told him the whole story. And he says, you know what? Part of this guy's daily routine is he gets his caregiver to take him down to the senior center for lunch. They spend an hour and a half, 2 hours at the senior center and come back. The plumber says, you tell the caregiver when she leaves to leave the key on the overhang of the porch. I'll be parked right down the street. When I see them leave, I'll get the key, I'll go in, change the water heater, I'll be done and gone before he even gets back. He won't know I was there. So if you involve the vendors that you're dealing with and the other people involved in helping you deal with the issues that are presented in the case, they'll come up with solutions you never thought of. And sure enough, we got that water heater replaced. He never knew it. And behind the water heater, we find the gun we were missing. So it worked out good all the way around. No ammunition, because I had found the ammunition earlier and hauled it all out of there. It's not going here. There we go. Okay. So how do you maintain working knowledges of services? Well, you're here. You're seeing all of our exhibitors out in the exhibit hall. You're networking with them. You're networking with your colleagues right here. You're developing working knowledges of all the services, all the providers, and all the facilities available in your community all over the state. So this is what you're doing right here today and tomorrow with this conference. So, and you're staying current with the community resources by attending classes and listening to issues as presented by professionals, attorneys, CPAs, investment advisors, care managers, and maybe even me, about things that you might face in your caseload that you can get some hints about things to manage the cases. So you're adhering to this standard right here today in this conference. But you can also attend other NGA courses. Somebody in one of the courses that I was talking about, other providers of continuing education courses for professional fiduciaries. And of course there's NGA, there's NALA, there's various different tax institutes that the law schools put on. There's the Estate Planning Council probably in your local area. There's other meetings of geriatric care managers that meet periodically and have associations. There's a whole lot of other types of education courses you can go to that's not just PFAC, that's not just NGA, but are related to the type of work we have to do. So get that type of education also. So here's the big one that created a bit of a stir when I presented this at the NGA conference. You're not the direct service provider. And what I mean by that is there's somebody else out there that can provide that service that your client needs, that you need to hire that person to provide that service rather than do it yourself. And when I made that statement, a bunch of hands went up. What if my client needs to be driven and doesn't have any money and I can't pay for a taxi? Well, I mean, you can drive your client somewhere. This is not that, much of a black line in the sand here, but you shouldn't be the person who prepares the client's tax returns and gets paid a fee as the CPA or enrolled agent from the client's trust or from the client's conservatorship account. You shouldn't be the person who sells the client's real estate because you have a real estate broker's license like myself and collect a commission for selling the client's real estate. You shouldn't be doing that. You shouldn't be providing, everybody knows that you shouldn't be the manager of a care agency and providing the in-home care from your agency and while you're the conservator for the client. But those things have all happened. And you shouldn't be doing them. The reason why you shouldn't do them is because you as the conservator and the trustee are the person who is overseeing that task performed. And you're judging whether that task was adequately performed and worth the money that you're paying to have it performed. So if you're doing those services, you're judging your own performance. You're paying yourself for providing the service that you're supposed to be judging whether it's adequate and worth the money. So that's the ultimate conflict of interest. So don't be the service provider. Sure, you can drive your client to the doctor appointment because he can't afford a taxi. And sure, you can drive your client to the doctor appointment even if you can't afford a taxi, because it's better to have that meeting with your client while you're driving than just meet him there because he took a taxi or paratransit in your county or wherever it might be. But you can do those things because there's a reason for doing that beyond getting paid for providing the service. Yes?
As far as, for instance, preparing your client's tax return, if you're qualified to do that, isn't there also a code or in PFAC or fiduciary state bureau or the NGA,
Yeah.
you're supposed to use your skills?
Yeah, you're talking about Probate Code 2640 something. I've forgotten what it's called. But and I think what you're talking about is there a code somewhere that allows you to do that. And there is. But the code that allows you to do that says you have to get the court's authority before you provide the service. So for instance, I own Marshall Fiduciary Services. I have 4 people working for me. I provide services to my clients through Marshall Fiduciary Services. I pay the clients pay me, and I pay the employees. Clients don't pay the employees directly, they pay me. So I get the court's authority to provide services from Marshall Fiduciary Services to all of my clients, because the court needs to know that I'm not going to be doing all this work myself. My staff's going to be doing some of this work. So I get a court order authorizing me to provide services through Marshall Fiduciary Services. But I have to tell them that I'm the best and only organization that can provide those services to my client. And that's part of what you have to do to achieve that order from the court. And of course, I'm the best and only because I'm not going to be the conservator and go have Richard Lambie's organization provide all the services. Richard would probably do a better job than I would, but it's not, that's not efficient for the client. It's not the efficient way for me to manage my client's services. So I'm going to be the person who is the conservator, and I'm going to assign all those jobs out to somebody else. I'm going to be one of my people who used to work for me years ago worked for me for about 4 or 5 months, and she says, "I get it now. You're like the orchestra leader. You don't play an instrument, but you make sure everybody else is playing the same tune." And that's what your job is as a conservator, fiduciary, whatever trustee, whatever your role is. You're making sure everybody's playing the same tune, but you don't provide those direct services. Any other questions about that one? So let's talk about confidentiality a little bit. You know, sometimes you get together with somebody, maybe at a family meeting or friends or something, and you're talking a little bit about a client, and I've told you a little bit about a couple of my war story clients here a little bit, but I was careful that you couldn't identify them. There might be a successor to me in the room that might have identified at least one of those cases, but that's a confidential conversation anyway. The rest of you didn't know what I was talking about. I hope, anyway, that's the kind of confidentiality we all will adhere to when we're talking to other colleagues or other family members or people at a cocktail party about what do you do when you're dealing with talking about your clients and talking about your role in the community. But what do you do when the press calls and asks you about a certain case that they heard about, that you have this case, and they want to know what happened with this case? And maybe your case was a case that when you settled the lawsuit many years ago, that lawsuit had its own notoriety and got a lot of press. And your client was embarrassed about the situation and didn't want to discuss it anymore and didn't want to hear about any of that stuff anymore. And now this issue raises itself again because the press calls you about that case. Do you talk to the press at all? No. Do you even answer their phone call? No. Do you let them write the article anyway? Of course, they'd write the article anyway. Suffer for them having written the article. Yes, you do. But you did the right thing. And it doesn't matter that the client didn't know that he was being written about, because when the article comes out, you could identify the client, even though it didn't use the person's name. You could identify who it is talking about because you know about the circumstances of the case that happened many years earlier. So that's the kind of confidentiality you need to maintain. I maintained my confidentiality that everybody else who knew that client knew that that article was about that client. The rest of you in your room probably don't have any idea, know what I'm talking about. I hope you don't. But it's a case that I'm comfortable with how it turned out, even though it didn't turn out well for me. Question? Yes.
So when you're doing your timesheets for submission to the court, and you're a conservative person, you're talking about what you've done to the client,
Right.
such and such a day and time. If you go into any detail on what you did, you are arguably revealing private information about the.
Yeah. No, I understand. I understand what you're talking about. On your timesheets, you're going to write down, you had a phone call with somebody, you talked to this person, you talked about that issue, and how do you make enough of a detailed description on your timesheet that the court's satisfied with the time that you spent without disclosing that kind of private information about your client. I'm very careful on my timesheets. My software that I use allows me to use a 25-character description. And that 25-character description is what appears on my invoice. All of the notes below that first line is mine. It doesn't go on my notes. But I've got the record of the conversation. I can go back years later and, what did I talk to that person about? And there it all is. And I don't do that well with it. My social worker does all that stuff, and she does a great job with her documentation. But anyway, so that's how I handle that. The description is just 25 characters long, and it tells me I had a conversation with that person, and we discussed this issue. It doesn't say what we discussed, what the solution was. It doesn't say what the outcome was, unless it's not a confidential conversation, and then I can go into it more in depth. And even more important, if you're describing a telephone call with your client, with your attorney, and that is attorney-client privilege communication, the telephone call, but you're going to bill for that call. And the description of that call is going to be on your invoice. You want to make sure that what you're describing on your invoice is not a part of the privileged conversation that you want everybody to see. You're just describing that you talked to them. You talked to them about this issue. You didn't talk about what advice was given. You didn't talk about what advice was requested. You just talked about the issue. So that's how I handle it. Anybody have anything different about that? Yes.
Yeah, in my timesheets, I just basically say, travel to more specific dermatology. I'm very specific about which doctor's office I'm going to, because if somebody was questioning the time that it took, I need to show, yeah, that's, where I went, and then recheck with Dr. So-and-so at the particular doctor's office, and then I just have in parentheses see file notes, so that I know that then I can take separate file notes, scan those, which are really handy, because when I have to scan my, look through my timesheets to try to remember what did you do with that doctor's appointment, that can get really cumbersome if you have to draw your timesheets to do that, even if you've got it in software. But if you have the file notes and you scan that and you know that that's, certain doctors didn't have it all organized that way in your electronic files, that's a little easier.
So let me see if I can boil that down. What you're saying is in your description that everybody sees, you say, went to see a certain doctor, you call the doctor by name, maybe even by the specialty that the doctor is, like dermatologist or psychiatrist. Wouldn't you get a little bit nervous? And then in parentheses say see file notes, so you know you've got some file notes about that. My first thought when you said that is, if I'm describing that I took my client to see a psychiatrist, is somebody going to know, oh, got a mental health issue here?
I don't normally say, I'll let them connect those dots. So I just say that I'm going to, yeah, it may be a cardiologist's office, so the title of the company is that.
Yeah. What I would say is took them to the doctor. I wouldn't describe which doctor. I wouldn't, because you put a doctor's name in there, somebody can look it up and see what kind of issue is going on there. And it depends how confidential you really need that to be. You might have a family that's very involved in all of this and they all know this stuff. And you don't expect to have a complaint from them. So it just depends. But I want to keep my standards the same, client by client by client, so I don't have to remember, oh, this one I got to do this, oh, that one I can do this. So I just am very careful about took the client to the doctor. And that's it. Now, I might, as I'm going through that and making the case notes that are in the notes field that are not revealed, I might remember, oh yeah, I can put some information, more information about that, and family will be interested to know this. So I'll describe that in there. And by the way, my invoices are sent to the family members every month. I print an invoice. It lists all my time, all my activities, all my staff's time, all the charges, everything, with a bottom line number of what it costs every month, and I send it out every single month. So that they, pardon me?
On a conservatorship?
Yes.
Before you get paid?
Yes.
Fees are approved?
Yes. It is a requirement in Santa Clara County, but I did it even before it was required, because I want them to know what's going on. I use, my invoices are generated from QuickBooks, but the time is all kept in a program called Time Matters. And I can send the time from Time Matters over to QuickBooks by an import-export program that's developed. So, what did we do here? think we covered this one, didn't we? Yeah, we did that. Okay. The guardian has the affirmative, and this is true of conservators too. You have the affirmative duty to terminate the conservatorship if there's a less restrictive alternative coming available. That doesn't mean up front you determine what's less restrictive, because yes, of course you have to do that. But even after the conservatorship has been established, if the person recovers, you have an affirmative duty to terminate the conservatorship. You can't imagine how rewarding that is to go to your client who's been under conservatorship, who hates the conservatorship, doesn't like you, doesn't like anybody involved in the case, and says, and you say, I think you recovered from that stroke well enough that we can get rid of the conservatorship. You can't imagine the glow on that person's face when you can get rid of the conservatorship and you're the person who presented it to them. And I've done it a number of times. And then, of course, we have a conservatorship, and we say, now what I'm going to do is I'm going to terminate the conservatorship, but we're going to tell the court we're going to put everything you have in a trust so it's still protected. You want to be protected, right? You want to be safe. You know I protected you all this time. We're going to put it in a trust. So we go to the court, we terminate the conservatorship, we establish a trust. That's less restrictive. That's the most rewarding part of the job, right there, is get the client off the conservatorship. That's what my goal is to prevent people from needing to be on conservatorship. That's why I take so many cases where I'm doing bill paying, making sure that the bills are all paid, and visit with the client and sort the mail out and write the checks, and they sign them and off it goes. And I do that with the clients when they're way beyond the scope of needing a conservator. They certainly would have needed a conservator by that time, but they still trust me to sign that check where I tell them to sign that check. And I prevent the need for conservatorship. Some people say I shouldn't do that because they don't have capacity. Well, early on I go into the case and I say to their attorney, who most of the time is referred to me by an attorney, probably to do this proper, I should have power of attorney to help the person manage their checking account. Or probably I should be put in their trust as successor trustee. Someday maybe they'll lose the capacity. And so we get those things put into place early on while I'm still there, while that person still has capacity but can't manage their checking account because maybe they're legally blind now and they don't know what the bills say and they don't know how to. So there's all kinds of reasons why that works, but it's a rewarding piece of the job. You had a question? No?
I did.
Okay.
What happens if it's the family members that petition the court to have a conservatorship put in place? Then is the conservator obligated to limit or terminate the guardianship when the guardianship is no longer necessary?
Question is, what if you're not the petitioner to be the conservator? And I'll talk about being a petitioner later on because that's another part of this. But what if you're not the petitioner, the family member petitioned to have the guardianship or conservatorship put in place, and you simply got appointed either because family member petitioned to have you appointed, which is a good thing, or family members were warring with competing petitions and the court said, neither one of you are getting it, it's going to be Marshall? So you're the one who ends up with the conservatorship. You still have that same affirmative duty. It's right there in the code. Even though you didn't petition to form the conservatorship, you still have that duty to terminate it if the person recovers sufficiently, if they've regained capacity. And of course, to terminate conservatorship, you've got to go through the same formation of a conservatorship in reverse. You've got to get the doctor's declaration, the CAP deck. The CAP deck is submitted to the court. Doctor says, yeah, everything's fine. Court says, yeah. The court investigator checks it out. Yeah, everything's fine. Yeah, you get off conservatorship. You don't get the doctor's CAP deck and you won't get off the conservatorship. So it becomes, gee, I tried. Doctor didn't agree with me. So now you're on their side again because you did what you needed to do, but just the professionals that you relied on to get this to happen didn't agree with you. So let's just keep trying. You keep doing what the doctor says for another 6 months. We'll go back again and see what happens then. Okay, so there's the affirmative duty. Medical decision making. Determine whether they've executed any advance directives, living wills, durable power of attorneys, any other thing. We talked about this in the beginning, but this is that same standard, is making sure that you know, and this is an ethical standard, you know what they would have wanted. And here is one of the other real moral conundrums we get in sometimes. A person may have written something in the advance directive about how they wanted their end of life handled, and you may not morally agree with that. And you can't let your morals interfere with that. You have to make the decisions in line with what they said they wanted, what they wrote in their advance directives. And your only option in that case, if you don't want to morally do what they say they wanted to have done, is to resign. Robert.
But many times what they said is not what they think now.
Okay. Oh, Robert brings up an interesting point, and there's a whole 2.5 hour or hour and a half session, the hour and a half session about what happened in Washington State when the person who said what they wanted for years and years and years, said what they wanted to happen, changed their mind.
Oh, that's the attorney wrote it that way, and now they
Yes,
understand.
they changed their mind. So yeah, and take a look at how the Department of Health Services in Washington really did a disservice to that guardian up there who did what the client wanted and supposedly didn't check with the client to see if they still wanted it. And the client died, and the Department of Health Services still came after them, even though nobody else did. The family was all okay, because the family knew that that's what the client wanted to happen. Okay, yes?
Where does the polls fit into those things? Since the polls is going to be the last document that is signed.
Well, the Post is I think the Post kind of supersedes the Advanced Healthcare Directive, because the Post is actually, the Advanced Healthcare Directive is something that, I mean, you could get a form and fill out an Advanced Healthcare Directive, or you can go to your attorney and have one specifically drafted that's an Advanced Healthcare Directive. Or when your doctor and you, or your client, converse about what they want, and that's all put down on a Post order, that becomes a doctor's order. And the nurses and the other care providers have to follow the doctor's order. And that's more powerful to them than the court order. So that's how Post fits into this. And I have another war story to tell you about my client who, for years, her husband died probably 15 or 18 years before her, and she was living in her home with 2 caregivers because they had tons of money. And so they had 2 live-in caregivers that would alternate paying attention to her. And she had a wonderful life and loved the caregivers. And one day she's a little short of breath, and the caregiver decides to take her to the hospital. And she's short of breath, and she gets in the hospital, and the hospital says, well, if you need assistance breathing, would you like to, us to do all the heroic measures and make sure you want to breathe? And she says, well, yes, of course. Well, she had an Advanced Healthcare Directive, and her husband had a mirroring Advanced Healthcare Directive that was specially drafted. It wasn't boilerplate. These were very specific Advanced Healthcare Directives that said exactly the opposite. But she, when she went into the hospital, said, yes, of course, I want heroic measures taken, because she thought she's just short of breath. She went into a coma. 8 days later, she died because they were taking heroic measures, because she essentially revoked that power of attorney when she went into court and said, yes, I want to vote. So we had to go to court and get the court to authorize us to remove the life support from her. Fortunately for me, I said, this was Stanford Hospital. Use their name because they know this case, and they are glad that I did what I did. I said to them, it's going to take me days to get into court. You and your ethics committee can decide that this poor woman doesn't need to have this treatment anymore. And you can see this Advanced Healthcare Directive that I provided for you. And I know she revoked it when she came to the hospital. I know that. But you look at this Advanced Healthcare Directive and what it says. And then you look at what you're putting her through every single day. And have your ethics committee make a decision. And they did. Before I even got to court, the ethics committee made a decision to withdraw life support. And it was just what should have happened. Richard. Oh, thank you. Okay. So. Attorneys can revoke posts? I didn't know that. Okay. Okay. Okay, we did that. Here's the standard about avoiding conflict of interest. And we talked a little bit about this in the beginning, but I wanted to bring it up here. Sometimes new people that I'm mentoring come to me with a question about, I'm just concerned about whether there's a conflict of interest in here or not. And I usually say, if you question whether there is, there is. If it raises a question in your own mind, it's a conflict. So, and sometimes it's crystal clear that there's not, but there really is. So be careful of that. Don't just say, oh, I didn't question that, so I thought it was. Marshall told me it was okay. That's not what I'm saying. But if you're questioning whether there's a conflict, there's a conflict. Be careful of that. Not providing direct services. Did we discuss that enough? I think we did. Is it bedtime yet? Almost. When they told me that I was doing this session, I said, you know, that's past my bedtime. I'm going to be taking a nap pretty soon. Okay. All these things are about ancillary services, providing ancillary services and direct housing and medical, and exceptions can be made when you demonstrate it's in the best interest that nobody else can do. We've talked about all these things. So, here's another one. Don't represent both the person and the service provider. I don't know how that happens. Guardian for both people, conservator for both people. Serving as an expert witness. Only once have ever been an expert witness in a case when I was involved as a fiduciary, and that was a trust case. And I don't know how that happened, because people say, you can't be expert witness and precipitant witness at the same time. But it did. The judge qualified me, so that happened. But this standard says you shouldn't do that. Don't accept incentives from service providers. You're going to get people who you're trying to place in a residential care facility, and they want to give you half the first month's rent, or maybe more. Because people who do placement services, they get that as their commission for placing somebody in one of those facilities. I usually say, if you want to give that incentive, if you're willing to give up that much money, give it to my client. Give them half instead of paying the full first month rent, we'll pay you half the first month rent, because I can't take it. Oh, no, we don't do that. Okay, you don't get my client, and move on. This is a guardian who's an attorney also. Any of those in the room? We don't have to discuss that one. And this is the one I was talking about, that petition the court for approval. When you provide, that's standard L, 16L. When you provide services and you're the best and only one who can provide those services to the client. Manage their finances in a way that maximizes their dignity. Try to set up a bank account if you can get away with it. Set up a bank account for your client's allowance to go into. Usually, it's not legal for a person under conservatorship to have a bank account, because they don't have a capacity to sign the service agreement with the bank. But I've had some of them that have gone down there with the care provider and opened a little bank account to deposit their allowance check in. And so, I mean, I really don't upset that, because that's what they want, and it's only the measly little allowance check that I don't have to account for anyway. So I kind of look the other way with that one. But one of my very early clients had a bank account that was set up, and I went to the bank with him. Little did I know that you can't have a conservatee and also have a bank account. So he signed the bank signature card, and I'm the conservator sitting there with him, and the bank said, well, you got to sign it too. You're the conservator. So I did. Years and years and years later, I find out that I'm a co-owner on that account. They put me on that account as a secondary owner. Oh, no. Yeah, so it's another Wells Fargo trick. It's okay. Wishes in practice, best interest standard. You got to look at the best interest standard and the substitute judgment standard, which is all over these NGA standards of practice. And you can, if the best wishes is what you have to do if you have no idea what the client would have wanted. The substitute judgment is where you're making judgments that you know that the client would have wanted you to do those actions in that way, because you know that about the client. From whatever means you know it, you know it. Don't act beyond your authority. Manage the estate only for the person. That's pretty obvious. And keep accurate records, obviously. No commingling. Does anybody know what commingling really is? Is mixing your money with the client. You can mix two clients' monies together. That's not commingling. Didn't know that, but we don't do that anyway. But yeah. Defend the estate, making claims against others. Make sure you follow accounting procedures. Follow the court rules. And report abuse. Even if you've satisfied the issue, even if you've prevented the abuse, still report to APS about the attempted abuse. You're responsible, you're a mandatory reporter, you are the first person, and you need to report the abuse to APS. We talked about the appearance of conflict of interest. That's been all over this. Don't commingle your personal funds, but of course you can advance your funds and get repaid. You know that. You can't transfer property to your spouse or your family members. Can't make a loan unless you get court approval. Don't support individuals indirectly unless you get court order. This is family members. The disabled son that has been receiving support all his life, don't support him unless you get the court order. Limit the guardianship, we talked about that. We don't do limited guardianships for this reason in California, but we talked about termination at length. Also, making sure that you have that they've regained capacity before you do that. We talked about those. There's some standards in here about what to do when the person dies. Manage your caseload appropriately. Don't take on too many cases. Don't take on cases that you don't know about because they're interesting to learn. You want to make sure you know about the case before you take on a case like that, or if you have a really good mentor, or if you need a really good mentor, call Richard. Right? Okay. Okay, so we talked a little bit about that. We need to talk about fees for just a second. There's standards in the rules of court in California about what how you have to set forth your fees in a way that benefit the estate, that the court can look at the standards, and they're in the rules of court, in the local rules, and not the local rules, but the state rules of court in California. So what NGA is saying here is really very similar to what we have in our state rules of court. So take a look at those. My own declaration in support of my fees lists those standards that are in the rule of court, and I write a narrative about how everything I did is meeting one of those standards, so the judge can see the standards as set forth in the rules and my narrative about what I did and how those activities met those standards. And the other thing about my fees is I don't charge one hourly rate. I have 5 hourly rates. My top rate for litigation cases, my next rate for difficult cases and skillful activities, my base rate, my reduced rate for things that I really shouldn't be doing, that my staff should be doing, and I did it anyway, and I'm going to charge for it, and then my free. And I have a free rate because, yes, the activities that I do that I'm not charging for appear on my invoice as zero charge. But first of all, I want to know that I did it. I want to know why I did it, and I'm keeping notes about why I did it in my database. But also I want the court and the family and everybody involved in the case to know that I did some stuff for free. So that's all part of, and my staff has the same kind of a laddered fee schedule too for their fees. They don't charge one rate for all of the work they do. It depends on the task performed, not the person performing the task. So that's the end of the discussion. Anybody have any final questions? Okay, thank you very much.
So Russ, thank you very much. PFAC does have a gift for you. It's so valuable it's being kept in a locked room right now. Please fill in your valuations and keep them at the back of the room and hold your seats just for another few seconds. We have a raffle drawing from Manufacturers Bank, so please bear with us as we draw the winner of the raffle.
We're going to let you do it, Richard.
I get on the hot seat again.
You do.
And the winner is Jack Montgomery of Pays Montgomery Fiduciary Services. So Pays is the winner. Thank you very much. Have a great evening. Be safe. Thank you.